It's my pleasure. Thank you. And thank you, everybody, for having me. And thank you, Tom, for reaching out to me and inviting me to be here to speak to you guys. So if you don't like my presentation, there's the man to blame right there. So my name is Andy Marcantel. Just by way of introduction, I'm a criminal defense attorney. I defend people who are charged with crimes. And so my presentation is going to be a little bit biased towards that, right? Everybody in this room has different lenses that they look through the types of issues that I'm going to talk about tonight. This is a group of concerned citizens. This is a group that some of us may have problems in our neighborhoods, some of us may notice criminal traffic in our neighborhoods. We're concerned citizens. And so we all have, as with our citizens' hats, we all have certain concerns we bring to the table. The police have other considerations. And before I go any further, I just want to acknowledge, I love it when I see law enforcement at these types of community outreach events, and that work that they're doing in the community sounds like they're doing an awesome job. So this is a tactic. I'm trying to butter them up before I tell you guys not to talk to them. But just so you know a little bit about me, I am licensed to practice law in Arizona and Hawaii. I'm also licensed to practice federally. I've argued in front of the Court of Appeals on numerous occasions. And I also practice law nationally. My law firm has a program called the Attorneys on Retainer program. It's a national program. If you're interested in it, certainly come and talk to us afterwards. This is for competent gun owners and people who want to feel protected using self-defense in their day-to-day life. Now, how this program works is you sign up for the program, and if you ever have an incident where you are forced to act in self-defense, to defend yourself, to defend your family, to defend your home, to defend your backyard. If you ever have to act in self-defense, we jump into action and we represent you absolutely no charge to you. So it's a monthly fee. You sign up for it for that peace of mind. If you're interested, we'd love to talk to you about it afterwards. It's called the Attorneys on Retainer program. The website is attorneysonretainer.us. You can sign up yourself. We got family plans, discounts, things like that. Check it out. Commercial over, I promise. But because of that program, I actually have cases right now all over the United States representing competent gun owners in self-defense incidents. I have cases in Texas, California, New York, Georgia, Florida, Nevada, and actually I'm hopping a plane in the morning to go to Washington, D.C., where I'm representing one of the individuals who was charged in the January 6th incident, and I'll be representing him in a very high-profile hearing tomorrow, so sorry if you see me again tomorrow on the news. You can say, I know that guy. Yes, so if you're interested in that, let us know. I also love pro bono cases. And I always like to say this to groups that I speak to because I'm always on the lookout for them. You heard that the name of my law firm is the Attorneys for Freedom Law Firm. Now, that's not just a slick name. It's a cool name, but it's not just a name. We are pro-freedom activists. And we are always on the lookout for when people's rights, constitutional rights, rights under statutory law, are being threatened by an overreaching government, by maybe bad cops, because they do exist, being threatened in the criminal justice system. We like seeking out those types of cases and representing those people for free. So if you guys are aware of anything that you think would be a good freedom issue, call us, talk to us about it. We're always on the lookout for these. And that also leads us around the country to do these types of cases. Also, last thing, I have a YouTube channel. If you go to Attorneys on Retainer on YouTube, I was recently informed that we have enough subscribers now so that I am now a YouTube influencer. It's a title that I never expected to have, and I still don't know what the heck it means. But if you go...
Reach enough subscribers and viewers.
Okay, yeah, that's cool. I'll take it. So being a YouTube influencer, you can go to the YouTube and you're going to find lots of case law analysis. You're going to find we talk about the Supreme Court decisions coming up. We talk about real high-profile cases and do analyses of what went wrong. Is this a good shoot or a bad shoot? Was there excessive force? Was this person in the wrong? You'll see full legal analysis by multiple attorneys. And I'll also have lots of tips on there, helpful legal tips like the ones I'm going to be sharing with you guys tonight. So I was asked to come here and speak to this crowd about your rights and responsibilities when interacting with law enforcement, okay? Now, I know lots of people have different opinions on this too. Since I've walked into this room, I've had like 2 or 3 people come up to me and say, now, Andy, we want to give you a warning. You see the cops in the back there. This is a very pro-police crowd. So make sure to keep your comments friendly to our boys in blue back there. And I certainly will, because I love the cops. I love the cops. They are absolutely necessary for our society. And I am very, very, very pro-good cop. But I'm also very, very, very anti-bad cop. And they do exist. And the issue with that is, and I'll tell you this, all of my friends who are police officers, there's nobody more pissed off about bad cops than the good police officers, okay? And there's nobody who wants to see that, because they get broad-brushed by the media, they get broad-brushed by people who just see something inflammatory on TV, and a lot of people lose sight of the fact that the vast majority of police officers are good people who are out there trying to make the world a better place and try to protect the community and trying to get success stories like the ones that they just shared with you. But I see bad cops too. And because of how much power our society gives bad cops, they are in a special position to do a particularly high amount of harm, okay? And so here's another thing I see often. This is another bias that I'm putting on the table for you guys, that I'm bringing to the table for this conversation. I see good cops with the best good faith intentions in their heart do the wrong thing. Maybe inadvertently, maybe accidentally. We're going to talk about a few examples of that from real cases that I've handled. But even good cops can make mistakes to the detriment of innocent people. That's my bias. I have seen in the thousands of criminal cases that I have handled, I have seen countless innocent people get charged with crimes or overcharged with crimes. And so that's what I want to talk to you about. I'm going to be telling you about your rights and responsibilities when interacting with the police. Now, you can choose to discard this advice, right? If you choose to, for example, I'm about to talk to you about why it's important to say as little as possible during a police investigation to the police. And if you choose to discard that advice, that's totally fine. All I can do is inform you of your rights that the founders of this country thought were so important so as to enshrine in our Bill of Rights. And you can choose to waive whatever of those rights you want to. But I'm going to inform you of exactly what those rights are. Now, kind of setting the tone for the different types of interactions, I want to go over 2 overarching principles. And the first is the one that I just referred to. I generally, as a criminal defense attorney, refer to this as the just shut up rule. The just shut up rule is pretty simple. And it's actually enshrined in our 5th Amendment to the Constitution. And you don't need to take my word for it that this is an important right, because I've made a deal with all the cops in town, and they've all agreed to read you this right. And in fact, the Supreme Court mandates those cops to read this to you. You guys know what I'm talking about? Anybody know Miranda warnings? You got it, 100%. You guys probably know it, but you have a right to remain silent. Anything you say can and will be used against you. And there's some information about your right to an attorney. Let's think about the language of the Miranda warning for a second. Can and will be used against you. Not for you, against you. They're making it very, very clear to you at that point exactly what those statements are going to be used for. On the other hand, says the Supreme Court of the United States and has been recognized by every single state court, your silence cannot be used against you. Okay? So a lot of people say this to me, Andy, if I don't talk to the cops when they come around, won't I look suspicious? Won't the prosecutor later be able to bring this up in a case against me and said, oh, as soon as the cops showed up, he wouldn't make a statement, he must be guilty? The answer to that question is no. The courts are crystal clear on this point. Your silence cannot be used against you in any way, shape, or form. If a prosecutor were to even try to bring some sort of an implication against you in court that you exercise that 5th Amendment right to remain silent as a bad thing, that's a mistrial. That case is going to get thrown out. I don't know, is anybody familiar with the Kyle Rittenhouse case? Kyle Rittenhouse case? This was an issue in the Kyle Rittenhouse case. The prosecutor introduced evidence that Kyle Rittenhouse invoked his right to remain silent and wouldn't give an interview to the police at the time of his arrest. The judge said very calmly, ladies and gentlemen of the jury, could you please be excused from the room for a second? I'm going to have a quick conversation with the prosecutor. And if you haven't seen this video, it's pretty priceless. There's a viral video where the judge just tears that prosecutor a new one. Tears him a new one and says, I can't even believe that you brought that up in front of the judge. I'm inclined to throw out this case. Now, ultimately, he was acquitted. But if he had not been acquitted, many legal scholars, myself included, believe the judge would have tossed the case for that reason alone. That's how important your Fifth Amendment right to remain silent is. This is the worst time after an incident when the cops are there investigating, the worst time to be making a statement. Usually, if the cops are there, if there was just an incident, you're stressed, you just went through potentially something traumatic, you just saw or experienced something very traumatic. We all like to think we'd be calm and collected under all circumstances, but in my experience, that is absolutely not the case. This is the worst time for you to be making a statement, because I think that in my experience, the Miranda warnings should be modified a little bit. I think they should go back and make it a little bit more accurate. Here's what they should say. Anything you say, and even things that you don't say, can and will be used against you if you don't choose to invoke your right to remain silent. So, in other words, what you're hoping is that if you make a statement to the police, they're going to record it accurately. Because I can't tell you how many times I have had a client take a look at a police report and say, Andy, I never said that. Yes, I made a statement and everything like that, but I never said that, or the way that I said it wasn't in the same way that the officer characterized it in that statement. Okay? Well, you hope at that point that there's body-worn camera, but if there's not body-worn camera, wasn't recorded or anything, you're hoping that it was recorded completely accurately. And once again, I am not trying to imply bad faith here. Good cops who show up to these incidents with the right thing in their heart, who want to solve the case, who want to solve the crime, who want to figure out who the bad guy is, they're human. And they make mistakes, even with the best intentions in their heart. They want to catch the bad guy so much sometimes that it comes out in the way that they characterize the police report. It's just a fact of life. So you're hoping, if you choose to waive your Fifth Amendment right, that it's going to be accurately recorded. But it's worse than that, because if you choose to waive your Fifth Amendment rights and give a statement when the cops arrive, you're actually hurting any future legal defenses you may have. Let me give you some examples, okay? I told you I represent gun owners, and gun owners who have to act in self-defense will oftentimes call 911 or make statements to the police. And if they followed my advice, they just shut up. But if they haven't followed my advice, sometimes they say something like, well, the reason I shot the guy was because I was in fear for my life. Okay. And there are even some groups like the NRA that advise you to say that on the phone to the police. But I disagree with that. I disagree with that entirely. The reason is this. The cops will tell you this too. There are a myriad of reasons why you could pull out your firearm, display it, discharge it, even shoot and kill somebody legally in Arizona that has nothing to do with being in fear for your life. We have some statutory law, defense of a third party, where you can use as much force as is reasonably necessary to protect a third party from deadly imminent physical force. You can imagine this scenario being a good Samaritan or protecting a family member or a loved one or something like that. That has nothing to do with being in fear for your life. If you've now made that statement, all you've done is foreclosed your future defense attorney from making that argument. We have another statute called 13411, ARS 13-411. That is what we call the General Crime Prevention Statute. I'm actually proud as an Arizonan that we have that. Because what that says is there are certain crimes that are so serious that if you see them committed in your presence and you have a reasonable opportunity to stop those crimes from being committed, you can use up to and including deadly physical force to stop those crimes from occurring. I encourage all competent gun owners in Arizona to read and study 13-411. Once again, has nothing to do with being in fear for your life. I'm picking on self-defense, but this really applies to all different situations, all different situations. There are a myriad of defenses that a competent criminal defense attorney can bring, and all you're doing is you're locking yourself, thinking that you're helping yourself in the moment, you're locking your defense theory into one particular theory. Maybe the evidence supports something else. Silence is also not a reason to arrest you. An officer cannot say, because he refused to talk to me, because she refused to make a statement on the scene, I, at that point, decided to make an arrest. I felt I had probable cause of a crime at that point because they didn't speak. That is not, it's been recognized universally by all courts to not constitute probable cause for an arrest. In almost all cases where my client chooses to open their mouth, they didn't know me ahead of time and they chose to open their big mouth and make statements, I feel like probably 85 to 90% of those cases, the worst piece of evidence for my client in the entire case came directly out of their mouth. So heed these warnings. Those cop friends that I told you about who, who don't like bad police officers, they've also shared something else with me. They shared that they tell their own kids not to talk to the police when the police show up investigating an incident. I think that tells you everything that you need to know right there. Yes, ma'am.
If you invoke your Fifth Amendment right and the police are trying to get you to talk and then you say, could I have a glass of water? Is that a bad thing? Now you've screwed it up? Because
No.
you said something very innocent?
No, not necessarily, right? I have seen things that my clients thought were benign or innocent be used against them, however. At that point, I asked her to make a statement. Instead of making a statement, she asked me for a glass of water. The report that I'm responding to indicated that the person was fleeing on foot. Therefore, the fact that she asked for a glass of water led me to believe that she was the fleeing suspect. I then had probable cause to arrest. I could give you, if you can't tell, I have seen every scenario under the sun. And so, yeah, I mean, you never know. You never know what you're dealing with, right? But as far as invoking your rights, and this is a really important point, you have to do it explicitly. You have to do it explicitly. What do I mean by that? You have to say, I want to speak to my lawyer. I want to speak to my attorney. There's some famous cases on this exact point where the client didn't, or the suspect at that point, did not invoke unilaterally and explicitly like that. They said something like, maybe I need a lawyer. That ain't enough. That ain't enough under the United States precedent to invoke your Fifth Amendment rights. Here's the kicker. Here's the kicker. Once you invoke your right to remain silent, all questioning must cease. All questioning related to the incident under investigation, anything that could involve solicitation of any information from you intended to incriminate you, must cease under the current precedent. Now, just because that's what the court says, that doesn't mean how it always shakes out in the real world, right? Sometimes cops will ask you questions regardless. Well, your future lawyer is very likely going to be able to get all of those statements suppressed, thrown out, in violation of your Fifth Amendment rights, okay? So make sure to invoke your rights very clearly. And another question I get is, well, Andy, if I invoke my rights and, I refuse to talk to the cops, won't that make me look really suspicious and increase my chances of being arrested? How do I do that in the best possible way? And the answer is, I suggest all of you blame it on me. Blame it on me. I'm sorry, officer, I get this crazy defense attorney named Andy. He told me I'm not allowed to talk to the cops unless he's here. Here's his business card. I'd like to call him immediately, please. It's funny, but a lot of cops will respond well to that. A lot of cops will go, okay, this person knows their rights. I know I'm not allowed to ask any more questions. If they have enough evidence at that point to make an arrest in their view, they'll make the arrest. But you're not making your situation worse for you. And in fact, if you guys want to grab one of my business cards at the end, I got them in the back, because on the back of that business card is a statement that was painstakingly crafted to invoke all of your constitutional rights under the Bill of Rights. And Arizona is what's called a statement adoption state, which basically means you can hand my business card to them and say, that's my statement, I want to call my lawyer. And you don't have to take my word for it, too, because I actually had an evidentiary hearing one time where my business card was admitted as a piece of evidence. I was proud of that. And the judge found, nope, this is sufficient to invoke your silence. So, I was like, yeah. So it's been confirmed in court. So yes, make sure to unequivocally do your rights. And also, let me say another thing here. This is so important. I'm talking about ways to avoid making your situation worse. Don't be rude to the cops. Don't be rude to the cops. There's no reason to do this whatsoever. You can invoke your rights and still be courteous and polite. You want to make your situation worse, be a jerk to the cops. Be a jerk to the cops, and you will not improve your situation in any way, shape, or form. Our founding fathers recognized that you can both invoke these important constitutional rights that they enshrined over 200 years ago and still value law enforcement in your community, okay? So those two things are not mutually exclusive. You shouldn't say, oh, screw you, I'm not going to talk to you, officer. That is a bad move. Don't do that. Because the police officer is probably there trying to help, is probably there trying to help the community. The next guiding principle I want to give you, this is on the same vein. If you believe that your rights are being violated, right? The cops show up and they want to talk to you. The cops pull you over and want to search your car. The cops show up at your house and want to come inside and search around, or they're in your yard poking around, and you don't think they should be. I don't think these cops should be talking to me like this. I don't think these cops should be searching my vehicle. The time to have that fight is not right there during the interaction with the cops. It's not on the side of the road. It's not in your yard.
Actually, I had cops show up at my house, and it was the wrong address.
Yes. Informing them that they're at the wrong address is totally acceptable, but not what I'm talking about.
Right.
I'm talking about, yeah.
But I mean, they showed up and they were like, you know, you're in there. I'm like, what's going on? What are you looking for? We're looking for this. Just down the street to the right. You're at the wrong house, you know?
Yeah, probably a good faith mistake on the part of the officers.
But it just didn't seem like they accepted, the answer, because our numbers was the same numbers as the house down the street.
My giving the benefit of the doubt to them is going to assume that they were working in good faith trying to figure out where to go and simply had the wrong address. And you should assert your rights at that point. But even that can be done courteously. Even that can be done politely with respect for the job that they're trying to do. Once again, this is a tactic to make the cops not hate me after the... But yeah, that's super important. You know, you need to be prepared in these types of situations to think on your feet. But once again, if you believe that your rights are being violated, the time to fight it is not there on the side of the road or at your front door or anything like that. The time to fight it is down the road, okay? Let's say that a cop does unconstitutionally search you, does unconstitutionally enter your home or something like that without a warrant or without exigent circumstances. If that's the case, and you're ultimately charged with a crime or something like that, you're gonna get some leverage out of that if you have a competent criminal defense attorney. You're gonna be able to get evidence thrown out, maybe the whole case pitched. If it's worse than that, you might even have a civil rights complaint against the police, and our office has handled many high-profile civil rights complaints against bad cops. But one thing's for sure, if you choose to have that fight with the cops there, resist arrest, refuse lawful commands, you're just going to screw up these possible avenues for yourself down the road. So don't screw up a potential evidentiary issue, and don't screw up a potential civil rights claim. If it's true that your rights were violated, fight that fight down the road. Be compliant with the officers. And the Supreme Court in Arizona says that it is unconstitutional, it's illegal, I should say, to resist even an unlawful arrest. So say that they showed up at your house, they had the wrong house, they showed up, they knocked on your door, you answered the door, and they say, "You're the suspect, turn around, we're putting the cuffs on you." You're like, "That's not me. That's not even my name. That's not me." Well, come on, you're coming with us. That is clearly a false arrest. That is clearly a bad arrest. Arizona law is clear on this. You cannot resist even an unlawful arrest. You fight that fight down the line. I'm telling you guys, comply with the police. And I don't know if anybody's a football fan or knows who Tyreek Hill is. Tyreek Hill is a football star who just recently found out the hard way. I think he's in Florida? Miami, yeah, that's right. He found out the hard way that the place to have this fight is not on the side of the road, because all of the precedent basically says you got to comply with the cops when they're there investigating, and if you got a problem with it or they did something wrong, you bring it up as a challenge down the line, okay? So yeah, super, super, super important to keep in mind. If you choose to fight the cops or resist arrest, like the gentleman that was referred to in the report earlier who didn't want to be arrested and chose to fight the cops, the predictable thing happened. He got charged with aggravated assault. So don't get bonus charges for yourself by resisting in the street. Okay, finally we move on to the do's and don'ts of traffic stops. Traffic stops. This is an important area. And the reason is this is your interaction with the police out in the world that you're most likely to have. In fact, everybody in this room probably at some point in their life has been either pulled over by the police or been a passenger in a vehicle that's been pulled over by the police. So this is a very likely interaction as far as these types of interactions go. It's important you know your rights and responsibilities during a traffic stop, okay? To set the tone here of why these things are so important and why it's important to keep your cool at all times during these. The statistics show that this is a very dangerous interaction for the police. The statistics show when they're walking up to that car, even the most seasoned officers I've spoke to get a little twinge of nervousness sometimes because they don't know who's in that vehicle. They don't know what they're dealing with. They don't know if they're dealing with a criminal who's got a gun, one of these guys whacked out on fentanyl who's dangerous to the community. That could be the person that they're about to greet and inform that they're going to have to pay a fine, right? So given the fact that this is a statistically dangerous interaction for the cops, I want you guys to keep that in mind if you ever see the red and blue lights turn on behind you. Keep in mind you don't want to make the officers nervous. Types of things that'll make the officers nervous: rifling around in your glove box and things like that, moving things around in your car, reaching around as they're walking up. I know that you want to get your license and registration prepared for them, but my suggestion is to keep your hands on 10 and 2 until you've had an interaction with the officers and they prompt you to give your documents, okay? So don't do things to make the officers nervous. Kill them with kindness. Even though you're not going to be making a whole lot of statements here, as we're talking about in a minute, there ain't no reason to be rude, okay? You be courteous and you behave yourself. Even if you feel like you've been pulled over for a total BS reason, it's not going to improve your circumstances to be rude. So, now, there are only a few things that you are required. Remember I said responsibilities. These are your legal responsibilities. There are only a few things that you are legally required to do during a traffic stop. And I'm going to list that short list for you right now. Number one is obvious, though hasn't been obvious to all of my clients over the years. You got to pull over. The lights come on behind you, you got to pull your car over to the side of the road in a safe manner, right? Don't run from the cops, even if you feel like you're not being treated properly. Pull over. Number two, we talked about it. If you're prompted to give your documents, your license, registration, proof of insurance, you got to hand those over. We're all required as Arizona drivers to keep those things current and hand those over and have them available during a traffic stop. Arizona's got a few niche laws. We got a few niche laws that aren't present in all states, and here's what they are. Number one, if an officer asks you if you have a firearm in the car, you must answer the question truthfully. They ask you, do you got a gun in the car? And you say, and you do, and you say no, you're going to be charged with a crime called misconduct involving weapons. Now, I'm going to get on my soapbox for just a second here. I think this law is unconstitutional. I think this law violates the Fifth Amendment to the United States Constitution. I think it violates the Arizona Constitution. The whole point of the Fifth Amendment is to prevent mandatory and compulsory self-incrimination. So you can imagine a situation where you're not allowed to have the gun, or the gun has a problem with the serial number, or something that the federal government says that the barrel's too long or too short or something like that. And you're asked this question by the cops. You're in a lose-lose-lose situation. We call this a cruel trilemma. If you answer the question truthfully, you're going to incriminate yourself. Exactly what the Fifth Amendment is trying to prevent. If you lie, you're going to incriminate yourself. You're going to be charged with misconduct involving weapons. If you don't answer the question, you're going to incriminate yourself because you just violated that statute. If anybody knows of anybody charged with this crime, I told you I'm looking for pro bono cases. For freedom issues, I think this is one. But that is a caveat of Arizona law. Truthfully answer the cop if they ask you if you have a firearm. Finally, you have to provide your full true name. Your full true name. If you're asked at any time, and this isn't just a vehicle, this is if you're out in the world and the cop has reasonable suspicion of a crime, and you are asked to provide your full true name, after being informed that it is a crime to deny them your full true name and still refusing it, you can be charged with a misdemeanor. So that's another to do in a traffic stop. Here's one, and I talked about this case a little bit earlier with Tariq Hill, who was forced out of his car, who told the cop said, "I need you to get out of the car, sir. Step out of the car." And he said, "I don't have to get out of my car." He did. He did have to get out of his car, as the officers proved to him as they escorted him to the ground outside of his vehicle. And they were in the legal right to do it, says the United States Supreme Court, Pennsylvania v. Mims. And that says that for something we call an officer safety exception, given all the concerns with traffic stops that we just covered, in the officer's mind, in order to protect our officers out there who are on patrol, we mandate that all people in vehicles have to get out upon request, no questions asked, okay? And this applies, there was a case in the 90s that extended the Mims ruling to passengers in the car as well. So basically, if you are told by the officer, get out of the vehicle, you got to get out of the vehicle. Finally, and we're going to jump ahead in the timeline here a little bit. Remember, we're talking about the rules, the only to-dos you have to do during a traffic stop. The final one is this. In Arizona, if you are arrested for a DUI, not under suspicion of a DUI, arrested for a DUI, and taken back to a police station or some sort of a traffic command station, you must consent to the blood draw. If they ask you for blood or breath, you must consent to that, or else they'll get a warrant. They'll take it forcefully if they need to. Seen that situation play out a few times, and it ain't pretty. And then they'll revoke your license for 1 year. It's called the implied consent rule. And so avoid that. In almost all situations, I'm going to recommend, I've had many late night phone calls with people who've called my office and said, I've just been arrested for a DUI. Should I consent to the blood draw? The answer is going to be probably yes, almost certainly yes to that question. So once again, you got to pull over. You got to give your documentations. If asked to get out of the car, you got to get out of the car. Your passengers too. You got to tell them truthfully if you have a firearm in the car and provide your full true name. And if you are arrested for a DUI, you got to consent to the blood or breath test back at the station. But that's it. That's it. That is all you legally have to do. You don't have to answer questions. Hey, where are you coming from? Where are you headed tonight? How long ago there's all kinds of opportunities there that the officers get to try to build probable cause of an arrest of like a DUI or some other crime at that point. Once again, good officers who might be part of a DUI task force, right? Certain areas have problems with DUI drivers sometimes, and so they'll create these DUI task force. You ever heard of the phrase, if you're a hammer, everything looks like a nail? I've seen that a lot of times with certain task force that are saying, you guys go out there and get as many DUIs in this community as you possibly can. Yes, ma'am.
Did you say that the last few of those requirements are in Arizona only?
There are other states that have similar laws, but those are the laws in Arizona. Those last three on that list differ depending on the jurisdiction. So, given that's all you legally have to do, here's one thing you don't have to do. You don't have to play the silly games on the side of the road. These things right here, field sobriety tests, law's a little weird here. The law says you're required to do them, but there is no penalty for not doing them. That's essentially, when you put the statutes side by side, that's the answer to that question. And I strongly, strongly, strongly advise, even if you are stone cold sober, not doing the field sobriety test. Yes, ma'am?
What if you're medically not able to do it?
I still don't even advise saying that. At that point, the suspect, who looked impaired to me, made up a thing that she was medically unable to do it.
But I had a card from my ear doctor.
I suggest letting your defense attorney make that argument down the line. I would simply say, while being polite and courteous to that officer, who's presumably out there trying to help the community, I suggest saying, I'm sorry, officer. My defense attorney told me I'm not allowed to do these tests. That's me. We already have an attorney-client relationship. This is great. Yes, I suggest being courteous and politely declining any questions, any tests, field sobriety tests. Some of them are very sneaky. They'll say, hey, just real quick, we're going to get you out of here real quick. Take a look at this pin and try to follow it real quick. Oh, it's sneaky. That's called the horizontal gaze nystagmus test. They're looking for cues of impairment. And to illustrate the bias that goes into the scorekeeper, because you're dealing with a biased scorekeeper here. The cop, who oftentimes has a direct incentive to arrest you, is the person unilaterally keeping score of how well you're doing on the field sobriety test. I have been to conferences where officers will call attorneys up and say, come on, let's do some tests. This will be fun. We were all stone cold sober. We weren't having it at the cocktail lounge. And they would call us up. And they would have the defense attorneys do these tests in the middle of the conference. All right, according to this, you have 6 cues of impairment on this, 4 cues of impairment on this, 8 cues of impairment on this. There's at least an 80% chance you're drunk right now. And we all laugh and everything. But that is the reality of the situation oftentimes. I have had cases where the cops showed numerous cues of impairment on field sobriety tests. Arrested a client and drew their blood, and the blood test came back with no drugs and no alcohol in it whatsoever. It's happened many, many, many times because officers are human. Officers are human. So I don't suggest taking the field sobriety test or answering any questions about where you're coming and going. Keep in mind, and we saw an illustration of this earlier with a great question that you asked, ma'am, which was, what if I say something or do something that I think is innocent? How it can sometimes be used by an officer to generate incriminating information. You're like, yeah, you know what, I'll just talk to him about my daughter or make small talk or something like that. At that point, I had a conversation with the suspect, and as she was talking to me about her daughter, I smelled alcohol on her breath or, identified this, that, or the next thing. And so therefore, that was one of my cues of impairment that I needed for probable cause. Things of that nature. As I spoke to her about her daughter, I noticed that she slurred every other word. I noticed that she didn't say things very clearly. That led me to believe she was under the influence of prescription drugs, and I made an arrest. So this is why my suggestion, when dealing with even good cops, is to invoke those important constitutional rights. There's a reason, folks, the founders put these in your Bill of Rights. Your Bill of Rights. It's because of reasons like this. They wanted to protect innocent citizens. Yes, ma'am.
I wanted to confirm I am taking notes here. So I can not do the field sobriety test movements, but then I do have to consent to a blood test.
Yes, ma'am. So yeah.
Okay, so it could have possibly have been 20 minutes on the street, could be 3 hours, but it protects my rights 100% by using the blood test if I am sober.
Yes, even if you're impaired. Like, even if it turns out that ultimately you're going to have alcohol in your blood, I still suggest consenting to the blood test because for the reasons I gave. If you don't, they're simply going to get a warrant, hold you down, and take it by force, which is unpleasant. Sir?
So when you're talking about the scenario, so if I say, no, I don't want to do a field sobriety test, they're going to be like, okay, so now the story's going forward, like, okay, I spilled alcohol, I saw pills, blah, blah, blah. That gives me probable cause. Isn't that like a setup?
Well,
that
remember
leads
what...
to a blood draw? I mean, because it's like, all right, so now you're going from probable cause to now if I say no and not consent because I know I'm legit, and then they go, okay, we're going to force a blood draw on you?
It's a great question because now I get to talk about my favorite constitutional amendment, which is the Fourth Amendment, to be free of unreasonable searches and seizures. And remember how we talked about earlier, the time to fight the cops is not there in the street on the side of the road. The time is down the road. So say that you're arrested, and what you'll hear cops say a lot, I've seen this phrase parroted on thousands of body camera videos. When a person invokes their right and doesn't do the field sobriety test, they say, look, man, we got to use the information that we have right now, and we think you're impaired. Turn around, here's your new bracelets, and then you're off to the station. If it turns out that was a setup, as you called it, or some sort of bad faith, or it turns out that simply, even in good faith, wasn't enough evidence to support probable cause, then down the line, your attorney is going to get to invoke your Fourth Amendment right and say, Judge, my client was unconstitutionally arrested. They needed probable cause. Here's the case law that says what probable cause is. Here's the factors against probable cause. Here's the factors the cops had for probable cause. And when doing the balancing test, according to this case law, this case law, this case law, they should not have arrested my client. Motion to suppress the unconstitutionally obtained evidence, i.e. your blood test results at the end. And if the judge agrees with me, those blood tests are gone, and the state's case oftentimes gone with it.
But I would still get that 1-year penalty of not having a driver's license since I did not consent to a blood draw.
Correct. This is a deal that you made with the regulatory agency called the MVD in Arizona. We all, when we sign up for our driver's license, sign a contract with the state of Arizona that says, I agree that if I'm arrested for a DUI, I will consent to a blood draw, or else I understand the officers will hold me down if necessary after obtaining a warrant and get it, and that I'll lose my license as a result. I don't think this is necessarily a bad thing. I don't want drunk drivers on my road. I don't want them out there as a citizen, right? Remember the biases we're dealing with here. Defense attorney hat comes off, here comes the citizen hat. I don't want those damn drunk drivers out there. I think this is a good policy, but it's something we all agree to regulatorily.
All right, so if, let's say like I do get arrested and they say, okay, it's gonna walk on, blah, blah, blah. I didn't consent, but when you did the blood test, it turns out, nothing was in there. So what happens if it becomes he said, she said against the cop that said I was drunk or on pills or whatever, and the blood tests come back negative?
Well, if there's no blood tests, if there's no alcohol or drugs in the blood, there's not going to be a following criminal case. So then I think your question is, well, then they ruined my night and stuck a needle in my arm, and it was very inconvenient.
But not only that, what are the repercussions afterwards to the the police officer that instigated this issue here, saying that hey, this person was drunk at the time?
Usually nothing.
Yeah.
Usually nothing. Usually no ramifications for something like that. And most of the time it should be nothing, in my opinion. Because, and this is...
Making up a story?
Well, if there's evidence, well, that's a different scenario. If there's evidence of bad faith, I have a different analysis. Now you may have a civil rights suit, or in the very least something called an IA, internal affairs complaint, or something like that, if you're incensed enough to try to get a mark on that cop's permanent record. I don't deal with that's a policy question about police departments. I don't deal with that. But if you're charged with a crime, you're going to get some leverage out of the fact that your Fourth Amendment rights were violated. There was another hand over here.
How soon can you or should you invoke your Fifth Amendment right? When you're out on the street or when they arrest you?
I would do it way before the arrest. I would do it way before the arrest. I would politely decline and say, I'm sorry, officer, I want to speak to my lawyer. I'm not going to answer any questions. I'd like to speak to my lawyer. I would do it very early on in the conversation, keeping in mind that you comply with all these other little nuances of Arizona law, firearms questions, true full name, stuff like that. Yes, ma'am.
So let's say I was drinking and I know that I'm probably over the level and I draw something out 3 hours and now I'm under the 0.08 because I made the situation last longer, so I sobered up a little bit before I asked for the warrant to get my blood again to prolong the situation. But what about the opposite? I know that I drank and then the interaction lasts longer and now I am over, but when I was driving I was under, but it took a while for the alcohol to adjust.
I love the hypotheticals there. No, there's two things I'll say in response to that. First of all, even if you wait 3 hours and you have you're way under the legal limit now and you have a small amount that shows up your blood, you're not out of the woods yet. Because what a prosecutor will do in that case is do something called a blood retrograde. And that is where they get a state scientist to come over from his lab and take a look at the results and say, well, according to my calculations, given her weight and body fat index and metabolism rate, it's on your ID. But they'll come up with a calculation and say somebody of this, size and shape and age and everything like that, because they had 0.03 in their blood 3 hours after the fact, according to my calculations, that means she was an extreme DUI with 0.15 at the time of driving. So you'll see them invoke some crazy math sometimes in these cases. Also, I'll mention this, the legislature thought about that question too. And that is why the DUI statutes, if you take a look at them, it's 28-1381A1, 28-1381A1, A2, and A3. And if you take a look at those statutes, the legislatures, they anticipated this challenge, and so they worded it in a way to say, within 2 hours of driving, you were above the legal limit, okay? Think about that for a second. If you, an hour and 59 minutes later, are over that legal limit, they can still technically charge you with the DUI, okay? So they thought about that. I'll get on the soapbox. I'm sorry to get on the soapbox again, guys, but I'm very opinionated about certain things. Let me get on the soapbox super quick. I hate this standard. I hate the standard for what constitutes a DUI in Arizona. You've probably heard this term. It is impaired to the slightest degree. Has anybody heard that before? If you are impaired to the slightest degree, you're guilty of a DUI in Arizona. That is a BS standard, in my opinion. Think about this. Riddle me this. You're the best driver in the state of Arizona. You're the most competent, you're a race car driver. You're the best, most skilled driver in the state of Arizona. And you drink just enough alcohol to make you the second best driver in Arizona. Guilty. Guilty of a DUI. You are impaired to the slightest degree. I think the standard needs to change.
Or you're a diabetic and your blood sugar is low.
Yes.
That can make you
Absolutely. And I've had so many DUIs with people coming from doctors' offices where they had gotten new prescriptions and they were told you're good to drive, and there ended up being reactions with other things going on in them that they didn't expect. So yeah, and that's a defense in your case. If that were to happen, you would have a defense for that.
There was a bullying issue I had, and if I had somebody coming running at me, I have to take the punch before I can use the gun to protect myself.
Okay,
That's coming from lawyers and police.
I'll respond to that. Lawyers and police. You can't broad brush any group. You cannot broad brush any group. And I can tell you with a high amount of confidence that not all cops in this state believe that theory of self-defense. I can tell you with confidence, based on a case that I literally resolved last week, where my client shot and killed somebody as they were being charged at with a knife. They didn't wait until they were struck. They didn't wait until they were hurt. The cops who investigated came up, questioned everybody, and I ended up having a very nice conversation while they were doing their investigation. And they informed me, Andy, this looks like clear self-defense. This looks like clear self-defense. I'm going to let the prosecutor know when I turn in my report, this looks like self-defense. And I definitely worded my report during the presentation to the grand jury. That's definitely going to make it look like self-defense. So not all cops have that theory of the law. Some might. I've heard cops with radical ideas. I've heard cops who say, in my opinion, Andy, no citizen should own guns. Only cops should have guns. Sounds like a good idea, right? But that's not all of them either. So you can't broad brush any group. I'm sure there are cops who told you that, who have that opinion, but that is not the universal case for cops. All right, perfect. Well, thank you guys again for having me. I appreciate it.